So the Secure Act is something that started back in 2020 and was reinforced in 2023. So the Secure Act first version was signed into law in 2019, taking effect in January 1 of 2020. And Secure Act 2.0 was modifying the first Secure Act legislation, and it took effect on January 1 of 2023. The question is, how does this impact how we recommend beneficiary designations of your IRAs? Well, your trust will qualify as a designated beneficiary. We have that set up, and we keep that updated as we go and maintain so that it will always qualify as a designated beneficiary as long as we're keeping you in our client family, our active client family. So our recommendation is that your trust be the primary beneficiary of your retirement plan and your spouse be the backup. Now, if you're not married, then your trust would be the primary beneficiary, and then some other individual or individuals would be the contingent beneficiary. So it's important that if you want to have the protections that are afforded in the trust, so remember, protection against later creditors of the beneficiaries, then you have to route the beneficiary designation through the trust. Your trust provides that your trust beneficiaries have that level of protection, but the law says that if you name an individual as the beneficiary of the retirement plan, then that individual's later creditors will be able to get to that retirement plan and liquidate it and pay off any judgments that they've gotten against your beneficiary. Your trust protects in that sense. So if your goal is, or one of your goals are, to make sure that your beneficiaries are protected, then you want to name your trust as the primary beneficiary. Now, some will say, and some who don't know what kind of trust that you have and what your trust says, they will say as a generic matter, oh, the spouse should be the primary beneficiary and the trust should be the backup. If we were to do that, and you were to say as a surviving spouse, well, you know, I would rather it go through the trust, because I would just prefer it to be that way, then you would have to say, I disclaim it to the trust. That process of disclaiming out of your name and into the trust would cause you to lose certain flexibility that is built into the trust for the surviving spouse. So it has an impact on how you structure the beneficiary designations. And it's important that it properly follow the order of trust first, spouse second. If the trust is named as the primary beneficiary and the surviving spouse would rather take it and roll it into their own name, they can, under the terms of your trust, take the retirement plan, disclaim it out of the trust so that it rolls over to them and it becomes the surviving spouse's. That process does not require the loss of any rights of the spouse in the trust. It keeps everything intact and provides the spouse with what they wanted, the rollover of the IRA beneficiaries. The spouse is not subject to the 10-year rule. All other beneficiaries would be, except for a few others. That's a subject of a different recording. I hope you found this to be of interest.